A federal judge just dealt a major legal setback to the White House's campaign against sanctuary policies. On July 25, 2025, U.S. District Judge Lindsay C. Jenkins dismissed the Trump administration's suit aimed at defunding 34 municipalities, concluding that forcing local governments to enforce federal immigration rules would violate the 10th Amendment. The ruling immediately protects Illinois jurisdictions, funding for housing, disaster relief and community programs while litigation continues, and it echoes earlier Supreme Court limits on coercive federal funding. Judge Jenkins's order does three things. It blocks attempts to cut funds to sanctuary cities. It affirms that the federal government cannot compel states and localities to carry out federal immigration functions, and it warns that conditioning grants to control local policy carries steep constitutional risks. The White House has not backed down. DOJ and DHS continue to publish non-compliance lists and press jurisdictions, and Attorney General Pam Bondi's August 19, 2025 warning signaled possible escalation. Some cities, like Louisville, changed course. Others, including Boston and Chicago, are holding firm. Legal scholars point to NFIB versus Sebelius and other precedents as limits on this enforcement playbook. Expect more lawsuits, heightened federal pressure, and careful judicial scrutiny as courts decide whether budget threats cross the line from persuasion into unconstitutional coercion. The stakes are clear. Federal immigration enforcement continues, but the government cannot commandeer state and local machinery simply by threatening funding.